Hello, everyone, and welcome to the Legal Power Hour, where we jam 60 minutes of thought-provoking discussion into a 30-minute show to awaken and protect our fellow American citizens. We are your co-hosts, Tom Scott and Sarah Nahidi, and today we have with us on our show Dan Brewington of Norwood, Ohio. He has a very interesting background. He has dealt with the Indiana court system for about the past 10 years, also featured in the documentary Divorce Court. Welcome to our show, Dan.
Thanks for having me.
Thank you for being here. Dan, can you tell the viewers a little bit about how you first came across experiencing the legal system?
Yes, in 2007, or I'm sorry, yes, 2007, over 10 years ago, my ex-wife filed for divorce. And the divorce was a 2.5-year process, but it wasn't anything like you hear, just a disastrous fighting, everything like that. It was just nobody filed for a final hearing, so it just went on for a long time. The problems and I've never been accused of assault, battery, domestic abuse, no child neglect. There's been no social services, no police involvement, anything like that. What happened is that we had a custody evaluation performed by a man in Erlanger, Kentucky. His name's Dr. Edward J. Connor of Connor and Associates, and he released a child custody evaluation report that just didn't make sense. I never fought for full custody. I was always, for joint custody. In a more conservative area, like it's a rural part of Indiana, in Milan, Indiana, I was working off the notion, worst case scenario, I'm getting every Wednesday and every other weekend for parenting. And, that I was just wanting to continue doing half and half. And so when this custody evaluation was released, there was just things that weren't right. Like he said that I couldn't communicate, and he had difficulties understanding me because he said I have severe ADHD. Well, he never contacted my. I do have attention deficit disorder, but it's not like I always use the joke that if I don't take my medicine, that I would be out jumping on the trampoline with the kids rather than doing the dishes, that sort of thing. But he said he couldn't communicate with me. So I started bringing up either or situations where if I can't communicate or he had difficulties understanding me, then he probably wasn't qualified to do his job, or he's lying, because he did evaluations for death row inmates in Kentucky, things of that nature. So it was just a bunch of things like that, and just things that were factually wrong, like the ages and names of my two daughters. And so when I started asking questions, I started out with an attorney, and at the provisional hearing in my divorce in January or February 2007, she just didn't submit the right financial documents. She just wasn't doing things that she was supposed to do. So I retained another attorney, where I got the evaluation. And the attorney said, well, you need another evaluation to combat this one. And I just questioned, well, why don't you challenge what he said? Because I have this information. And he's, at the time, I didn't know any better. He says, well, you don't do it that way. And so he wound up, because I kept asking questions, he wound up firing me. And so I just kept asking why. Well, then I started requesting I went to an attorney, and he didn't want to take my case, but he said, the first thing you need to do is get the custody evaluator's case file. And so I started asking for the case file, and that's when the problem started. Because if he's saying that he has difficulties communicating with me, I wanted to know why. If there's errors because he wrote the judge and him had some kind of communication where they came in agreement that we should have more sessions for a custody evaluation, because in the quote unquote numerous errors and oversights that were in the evaluation. After I had written a letter to the doctor, he wrote that. Well, I wanted to know why there were numerous errors and oversights. What was his records like? So I requested the case file, and he said that I wasn't allowed to have it under state and HIPAA laws. Well, then I gave him the information saying I was allowed to have the information. Well, then he said that he'd give it to me if he received confirmation that I was representing myself. Contacted the court. Yes, I was representing myself. Then he said that he interpreted a court's order to say I wasn't entitled to the case file. Well, there was no order, and there still isn't any order that said I wasn't entitled to the case file. And so I started going to the court with these things, saying he's not giving me consistent information. And so I keep presenting it. And then the court at the time said, in a hearing, he said that that we were to follow this. He actually issued an order. This is an Indiana judge saying that the order was, or I'm sorry, it was in court. He says that the order was to follow Kentucky law because he was in Kentucky in terms of the child custody evaluation. Well, that's ridiculous in itself, because there would be no way for the Indiana judge to enforce it. So later on in another hearing, the judge says, well, back last summer, I said, you're not entitled to the case file. And it was just because my ex had said that, claimed that her medical records were in there, and they said it would violate her rights. Well, we signed forms to release the information, obviously. And so it just kept piling on and piling on. Well, then the court started latching on to, I was trying to get her medical information. I just objectively, I don't know if her medical information was ever in there because I couldn't see it. He said he didn't want my mental health information, which I had, and I was going to give it to, because I'm an open person. I don't care what you know about me. A lot, most everything's online now anyway. But it just kept going and going, and my persistence of asking why turned into he's dangerous. Now, if I was dangerous, they never said anything about me being a danger to my children. So if you fast forward 2.5 years later, our final hearing, Dr. Connors testifying, saying that my actions are potentially dangerous because I kept questioning it. I can't accept reality, and everything like that. He's still saying that I could have equal time with the children. And so that was the last day of my final hearing, was on June 3rd, 2009. And 2.5 months later, the judge strips me of all parenting time in his order, saying that it said the court is most concerned with husband's irrational behavior and attacks on Dr. Edward J. Connor on the internet. And he set up the order where I had to jump through incredible hoops to be able to get back to my children, because there was no supervised visitation. And mind you, during the entire 2.5-year divorce, I never missed a day with the girls. I had them at the time when my wife filed, they were 1 and 3. So, and I had them nearly half of the time for 2.5 years, with no allegations of abuse, neglect, social service. Like I said, the judge just abruptly cuts off all my parenting time. And he said I had to undergo psychological evaluation. I had to, with a court-approved evaluator, I had to have that evaluation approved. I had to have supervised visitation in a therapeutic environment with a court-approved supervisor. If that was approved, then I could petition for unsupervised visitation and receive that only after, with a list of things that, which included removing all the internet content that might be harmful to the children. And so that was the whole thing. And I couldn't do that because I had to appeal the issue. One of which is because my parents, when my father died in 1998, they had farmland in a trust, and to my brother and I, and they said I was I had to pay my ex $121,000 for my future interest in a trust that there was no guarantee that I would ever get, and I won't, because that trust no longer exists, and I have no controlling interest, anything like that. And so the judge said he didn't have jurisdiction on appeal to rule on the custody things, and so he knew that I would just, he was just preventing me from even, attempting to get to my kids. Now, if he thought I was a danger, because he said I needed all this testing and supervised visitation to see if I was a potential danger to the children, my ex, or potentially myself. Well, no restraining orders were issued, or protective orders, anything like that, because if you would have done that, I would have had a right to a hearing or a right to a trial. So it was very methodical and well thought out. But the bottom line is, it was 2.5 months from the final hearing until the day he issues an order, just mails it out. And I found out because we were supposed to switch over the kids, and I get a text message from my ex saying, there'll be no switch over today. Orders are out. She already knew. I drove from, I was at my mother's house in Cincinnati, drove all the way out to Indiana, got the orders, and sure enough, he terminated all my parenting time. And so that's how everything started.
So Dan, this particular judge, alleged behavior on, was this on your blog? I mean, did he just pick this out of the air? I mean, how did he come up with, you're a danger? How did he come up with this analysis in his mind?
Because Dr. Connor and I accuse this Dr. Connor of ex parte communication. Well, it's not an accusation, it's a statement of fact, because Dr. Connor sent a letter to us saying that the previous judge in the case contacted me and with his agreement on additional sessions. Well, I wasn't part of that conversation. None of our attorneys were a part of that conversation. So that's, by definition, is ex parte communication. Well, that became one of the things where I was potentially dangerous. And then psychological testing. I wound up getting my psychological test results, which the doctor tried to say that the APA prohibited the release of it, and it doesn't, because I finally pointed that out to him and he gave it to me. There was one section of it slips my mind what test it was, but I scored out of 9 or 10. Like it was like 9 out of 10. I scored high or above average on like 9 of them. And then one, attention to detail or things attributed to ADD, that was the only one that I fell a little bit low on. And they ran with it. They ran within the criminal trial, which we haven't even gotten to yet, ran with the divorce. And they kept citing, because I've only had one psychological evaluation, and that was with that custody evaluation in 2007. And they've continued to rely on that I'm a danger because of that, yet the custody evaluation recommends almost equal parenting time.
I mean, it sounds to me like there was some kind of mutually beneficial relationship between the judge and Dr. Connors. I mean, have you been able to get to the bottom of what that is? Because there's some kind of bias or something going on between those two.
This is a perfect storm, because what happened was I had people contacting me left and right. And that's the sad thing is that because the retaliation is so swift and so severe, obviously people are afraid to speak out. Well, the reason I could speak out, because there were no allegations of abuse or neglect or anything like that. So they couldn't say, take it down. My ex filed for a protective order asking for the judge before the final hearing, asking the judge to force me to remove the internet content. He said no. He denied it. So he reviewed everything, It wasn't dangerous to the kids. And so what happened was people start contacting me. This happened to me. And I started looking at evaluations, and they say, oh, these are confidential, not allowed to talk about them. So people don't talk about it. I started comparing them. And the doctor, it really wasn't a woman or man thing or economic thing. It was just, people were going into this guy, and they were about equal parents, or, one of them may have been a little bit better or better situation for custody. And so he would just pick one and then make the other one sound like the axe murderer just to justify his position. The judge, on the other hand, his name is Judge James D. Humphrey. He's still a judge in Ripley County, Dearborn County, Indiana. He was just arrogant. He just didn't like the fact that I was asking so many questions. And then I would do things that were just like, they kept on saying I had severe ADD. I couldn't understand anything. I couldn't understand confidentiality. Couldn't understand, blah, blah, blah. So I filed a motion to withdraw from representing myself and requested special treatment from, in accordance with the Americans with Disabilities Act. Because they kept on saying, it's another, the either or thing that I refer to all the time, is that fine if you say I'm crazy or some kind of mental diminished capacity or something like that, then you have to give me the resources to understand what's going on. And so, but they would get mad at that. And so it was just, it just kept hanging, and there just wasn't a resolution other than, I'm just putting information onto the record thinking, at the next court, I might have some luck, because when I started reading case law, that was the big thing. Yes, preserving issues for appeal. So I objected to everything. I kept putting extraneous information into pleadings, and with the thought that I might do something on appeal. And so there's really there's no rhyme or reason. It's not. I mean, obviously that's his main guy, the doctor and the judge, but it's not like Cash for Kids. It's just backcountry, good old boy protecting their own sort of thing.
And you alluded to a criminal case. I mean, how did this become a criminal matter?
Well, and the divorce decree was issued in August of 2009. Well, obviously, I'm not happy when I can't see my children, and it's just sudden. I mean, and that's the scary thing about it, is that it was to punish you, because so much, and I've seen in so many cases, somebody messes up at one point of time, a parent, maybe it had some kind of domestic dispute, or having something to do with intoxication, public intoxication. And so the court will put their thumb on that and just hold somebody down. They didn't have anything on me because I'm just regular person. I couldn't get mad. And so they said I was dangerous. They say all these things. And so that would be the worst thing you could do to somebody who you think is unstable, is just to strip them out of the blue of the children without any protective orders or without any measures to protect the children's welfare or anything like that. So I started just investigating everything, trying to connect dots and things like that. I found out that his wife was listed as an advisor on the Ethics and Professionalism Committee. So I said, people need to contact her. And then they turned around and said that it wasn't that wasn't an appropriate position, because I'm just trying to get out as much information as possible. Now, they didn't file for any restraining orders. Nobody told me to stop. Nobody told me to take down any information. And I kept going. I started, I was on, a couple of radio shows, or mentioned on radio shows. I had people contacting me, and I went to a hearing for a friend that I had met, for the same thing, where this Dr. Connor was recommending that parents switch parenting time or switch custody year to year. This year, one parent gets it. Next year, the other parent gets it. I'm not a psychologist. I'm not a professional. it just didn't make sense, especially when the parents didn't live in the same school district. And so I just kept writing about that stuff and finding out where the connections were. Like the doctor, his dad was one of the most prolific high school coaches in the area. And so I just put that information out. Well, if you fast forward to 2011, former Dearborn County prosecutor F. Aaron Negengard makes me the target of a grand jury investigation for, I didn't even know at the time why, how he could do it, why he could do it. Well, he said intimidation of a judge, intimidation of Dr. Connor, intimidation of judge's wife, attempted obstruction of justice of my divorce. And so I go in, I testify, I have nothing to hide. And he instructs the jury in the grand jury transcripts that that I made over the top and unsubstantiated statements that crossed the lines of free speech and intimidation and harassment. Well, I wasn't charged with harassment, but there was no threat instruction. They just said I wasn't allowed to lie. And so I was, and mind you, in this year and a half from the final decree until I was indicted, there were no restraining orders. No, I mean, and I was living in Cincinnati, and so I was arrested in Cincinnati, booked in Cincinnati. I bonded out of Cincinnati, and volunteered. I volunteered to report to Dearborn County, Indiana, and they placed a $500,000 surety, $100,000 cash bond on me, and I wasn't able to bond out because they said that I was a flight risk, and that they never said why I was even there. They said it was just intimidation, but they said I don't follow orders of the court, and they said it's because I hadn't paid my ex all the money from the trust. I didn't follow through with the terms of my divorce decree. So that's the only thing. So they didn't say, here's the threat. I mean, they didn't try to subpoena my computer, internet records, anything like that. So there was never a thought of, oh, they think that I might hurt somebody or anything like that. They just put me in and locked the keys, locked away the keys. And my Ohio attorney, Robert G. Kelly, he's in the Divorce Corp documentary as well, he tried to visit me, and they wouldn't let him in. He coordinated with me bailing, posting bond in Cincinnati and reporting voluntarily. And the prosecutor even said, oh, well, since he got out late on Wednesday, just come in on Friday morning. And so went in, appeared for arraignment. Bob Kelly spoke at the arraignment, just on he's not licensed to practice in Indiana. And then when he went to see me after the arraignment, they wouldn't let him in because they said he had to be licensed in Indiana to be able to see, to be able to visit a client. Well, Dearborn County, Indiana, and Cincinnati is 20. The closest point is 15 or 20 minutes away, and so there's a lot of cross traffic there. So they just make up new rules for me, and so they wound up forcing him. He wound up getting licensed in the Federal District of Indiana, Southern District, just so he could come and visit me. But those are the things that just kept going and going and going, and so. And then, I mean, they appointed a public defender. The public defenders, Bob said that he said, just, let me know. I'll come in, and he would go pro hoc vice. For those who don't know, he would represent, basically piggyback off of the licensed attorney or the attorney licensed to practice in Indiana, and do everything for free. Nobody would call him. The first public defender withdrew after 2 months, saying he might have a conflict of interest. The first judge who set my bond at effectively $600,000, Sally McLaughlin, who was Sally Blankenship at the time. McLaughlin, she set my bond and then said that she had a conflict and withdrew. They appointed somebody else who said that he's very good friends with the judge, who's Judge Humphrey, who was the alleged victim of the case. So he withdrew. So then they appointed Judge Brian Hill out of Rush County, and he appointed for my public defender, Brian Barrett, the chief public defender of Rush County. And he never met with me inside the prison to discuss my case. The only time he ever talked to me was outside of the, or in the courtroom at hearings. So he went to trial without having any understanding or asking my input of the case.
And what happened at the trial?
What the trial, leading up to the trial, I kept telling the judge, I didn't even have indictment information. The indictment just said, for some of the cases, it was a 41-month period where the alleged illegal actions occurred. And so I have no idea. They said somewhere, around or about September 2000, 2007 to February 2011, this action occurred. I didn't know what action it was. And so it said my cumulative actions was what caused this. Why didn't, I didn't know if it was the legal ones and what was illegal. I just had no idea. So I kept on telling the judge, I don't know what they're charging me with. And the prosecutor never said anything. And so we go into trial. I filed 3 motions at the end of, and my attorney keeps saying, I'll come in to meet with you. I'll come in to meet with you. And he just never did. He would say that in court. Well, then in the final, or right before trial started, I'd filed, had my family take them to the court for me, 3 motions: a motion to dismiss for ineffective assistance counsel, a motion to dismiss for prosecutorial misconduct, a motion, and just another motion to dismiss, because I just didn't have any of the charges. And my attorney had never met with me. I had no idea of the direction of my case, just absolutely nothing. I was also charged with perjury, and I didn't even know what that was. And the only way that the only thing they gave me to rely on was the grand jury transcripts, which were 340 pages. And they said, this is how you're to determine what the charges consist of. Well, the problem with that was they didn't even include the beginning of the transcript. It started at witness testimony, and there was no instruction as to what the conduct was, except for the prosecutor saying, these are what my staff and I believe are over the top and unsubstantiated statements across the lines of intimidation and harassment. So I just had absolutely no idea what anything was. And so when I get to trial, the judge says, Mr. Brewington, you filed 3 motions pro se. He didn't, it wasn't likely they would hear them because I had had counsel. He says, so what you're telling me is that by filing these, you want to represent yourself? And no, I want competent counsel. I don't know this, I don't know that. I went on and on. And he says, do you want representation or not? And I'm like, yeah, I want competent counsel. He says, that's what I need to hear. He says, Mr. Barrett, continue. And they started trial. At no point did he turn to the chief, who's the chief public defender of Rush County, whose office is in the same courthouse as him. No point did he say, Mr. Barrett, is this true? Have you not met with him? At no point did he say, Mr. Brewington, what don't you understand about the charges? Because, and that goes with the either or thing. They argue that I don't understand, that I'm potentially dangerous, all these things, and mentally defunct. But at the same time, they don't even tell me what the charges are to make sure that I understand them. And so so then I was, after a 3-day trial, I was convicted. I mean, my attorney had made no attempts to contact any of my witnesses. You know, Bob Kelly, my friend and attorney, and I mean, this guy, he's been a practicing attorney and been elected law director in the city and things like that, and they just refused to contact him. And he said he'd provide him with evidence, provide him witness lists, everything like that. The public defender Brian Barrett didn't do anything. And so they just let it run. I was convicted. Then they sentenced me to 5 years, to which I only had to do 2.5. I mean, only had to do. And so I spent 2.5 years behind bars. And so
that's outrageous. I mean, yeah, that's what you're saying. I really hope our viewers are listening to this. This can happen to anyone. And what you're saying is a confluence of illegalities the system portrayed upon you. I mean, Sarah actually has a client she's working with now, very similar to 5 errors in that case. But for someone like an ordinary person to get convicted and state in open court that he has no competent representation, and for the judge to just mow right over that, and this goes on every day in every court across the nation. This is not some rare, weird occurrence that doesn't happen. I just, I really don't have much to add other than that. This is just outrageous.
It just keeps going. Because then what you have is the appellate process. Well, the Court of Appeals ruled that first they said I had the one charge I wasn't convicted on was releasing grand jury information. I was indicted on releasing grand jury information, and they didn't have any evidence that I did. And so that one was I was found not guilty. And then there was no evidence that I tried to intimidation of the judge's wife, the obstruction of justice, and intimidation of Dr. Connor, that constituted double jeopardy. So the obstruction charge held because it was a felony, and the other one was the lighter of the two, so that held. But the Indiana Court of Appeals ruled that even if my statements were true, that a true statement could be a threat. And so that at that point, then we had Peter Volok, or I'm sorry, not Peter, Eugene Volok, constitutional scholar. He signed on. I mean, just there's conservative, liberal people. Jim Bopp signed on to him. He was one of the front runners of Citizens United. Some of them are slipping my mind. Different associations signed on as amici, and so it went to the Supreme Court. Mind you, my appellate lawyer, his name's Michael Sutherland. The whole time I'm telling him, hey, I didn't know what the judge. I didn't know the charges. I didn't have an attorney. I told him everything, and he says, well, it would go back in front of the same judge, the post conviction, and he wouldn't hear it any other way. And so
your appeal in Indiana or Ohio?
Everything's in Indiana.
Okay.
I mean, I wish it was in Ohio, because
I have a good friend who does appellate work in Ohio, and I'm like, you need to talk to him, but I don't know.
Well, and see, that's the thing, is that it just became so convoluted that nobody wanted to touch it, because obviously of the ramifications of what happens when you contest this power. Well, I went to the Indiana Supreme Court, and they ruled that they found that the prosecutor made both a constitutional and unconstitutional argument at a trial. Well, right off the bat, that should have been a basis to throw everything out. Said that they argued both true, and they cited the line in the record of the transcript, and then on page, I think it was 455, the prosecutor argued both true threats and threats to reputation. Well, that was at the end of the trial when they first made any kind of mention, and it was just a blanket reading of the statute. So that's an obvious problem. They said I invited the error because my attorney tried to take advantage of the prosecution's unconstitutional argument. Well, these came from indictments. I mean, if he made the same, he would have to make the same argument in the indictments, which means that, I couldn't invite that. And then on fundamental error and ineffective assistance of counsel, the she's a Chief Justice. Chief Justice Loretta H. Rush wrote that fundamental error is much like, it says the first time that we've addressed this, fundamental error is much like ineffective assistance of counsel, from the standpoint that fundamental error is the judge not reacting to the attorney's non-objection, and ineffective assistance of counsel is vice versa. They worded it in a way where they said the judge realized that it was trial strategy by my public defender to do nothing. And because that trial strategy, was, it said constitutionally imprecise, but still pragmatic or something, that's what waived my right. And this guy, and it's in the record where I said he's never met with me, so he could have never built any kind of defense. But that's just what they did, and they wrote everything off. And then they went on to say that that I had a very, very good understanding of First Amendment law, and it was all part of my trial strategy. Well, in Indiana, post-conviction hearings are the appropriate venue for trial strategy arguments, because obviously there's no evidence or any kind of documentation of what a person's trial strategy is prior to a hearing discussing such. Well, they just speculated and jumped around and tried to build stuff to have this argument. And so then when you go and further investigate it, find out that the Indiana Supreme Court judge, Chief Justice Loretta H. Rush, she was in a graduating class with Judge Humphrey, the victim. She at Indiana University, she served on a committee. What's that?
Why didn't she recuse herself if she knew the person who was the victim of the action?
She actually served on the Juvenile Justice Improvement Committee with Judge Humphrey, as well as the first judge of my divorce, Judge Carl H. Tall, and served for years, and then continued to serve with them. And it's in the meeting notes, and continued to serve with them while my case was was before the Indiana Supreme Court. And my case took the longest of any civil or any criminal case, and I think there's only one civil case that took longer. It was before the court for 430 days, I believe, and they just drug everything out. And so then, I had to do the full 2.5 years, and now I'm battling everything in a post-conviction proceeding. As well, I'm appealing that matter, as well as I'm still have a lawsuit seeking public records because they didn't provide me with the whole grand jury record, and which is immediate grounds for dismissal, because and now they're saying it's complete, and they're hedging on not giving me the grand jury audio. And that's a whole nother crazy story in itself. My family started asking for the grand jury audio and the audio from these hearings, and they're like, "Oh, well, the hearings didn't occur." Well, obviously the hearings occurred when people said we had affidavits of people who were there. Oh, yeah, well, then it was a mistake. And then they were going to release the grand jury audio, but then they said that after 3 weeks after in 2012, when my mom requested it and my brother, they said that it's come to their attention it wasn't admitted as evidence, so they weren't going to release it. And then in 2016, I put in a request for it, and they said that essentially I didn't have a good enough reason to release it. Well, that's not what you said before, and I don't need a reason for a public records request. If it's, if you're not going to release it, you don't release it, but you don't say that, hey, I didn't give enough reason. And so then I filed a complaint with the public access counselor in Indiana, and they actually ruled in my favor, said, they have to release it. So then the judge, who's Judge Brian Hill, states that I was he knew he had the authority to release it, and he just started making excuses. Well, finally he said that I can have it, but it came to his attention, and granted, this judge is a special judge appointed. He's an hour away from Dearborn County, Indiana. Came to his attention that there was other grand jury proceedings intertwined with the audio of mine, and so he said that told the court reporter to only include portions of my proceedings. And so right off the bat, you say that sounds so much like a wink-wink deal. And it pretty much was, because when I got the audio, it had less content than the transcripts from which it was allegedly transcribed from. And so I started asking, I kept asking for it. They want to give it to me. And so I filed a lawsuit, and which is still pending. And I filed a post-conviction a petition for post-conviction relief, and that just got denied. And the judge said that that there wasn't any evidence to support what I was doing, without any hearings, without anything. And and just awarded the state summary judgment just out of nowhere. I mean, because I filed a motion for summary judgment, and the judge said that it wasn't appropriate in post-conviction because it should have been summary disposition, which case law has, it's the same thing. And he said, but even though the state didn't request summary disposition, he awarded judgment to him, and without any explanation as to 20 of my claims. And it's just the thing where they keep on turning their heads, and they don't want to say, what's the problem? Why are you claiming that nobody met with you? What don't you understand about the charges? They won't say it. They just keep ignoring it and keep denying. And so I have to, basically, they're just trying to wait me out. Or I was thinking about taking it to a federal level, but because it's so simple, the Indiana post-conviction states that the court shall make specific findings in fact and conclusions of law on all issues presented, whether or not a trial is heard. The court essentially says that it'll make look at all findings, and their biggest argument was that there were he says that there's no issues of material fact. Well, in the state's response to my motion for summary judgment, there's a headline, I'll hold it up. It says, multiple issues of material fact exist. The state argued against summary disposition and summary judgment, saying it's not appropriate because there's these issues of material fact, and the judge awarded the state summary judgment. So it's just, and that was Special Judge W. Gregory Coy out of Switzerland County, Indiana. And so that's where I am now. And it just keeps snowballing. And there's nothing else to put into it to make it sound any more glamorous or crazy or anything. It's for lack of a better word, just stupid. And it's just increasingly, it just gets dumber and dumber because there aren't any words. They just keep trying to stomp me out, and I don't care. This is I used to get excited about having to respond or something like that, and it's just kind of like I gotta push myself to file an appeal. It's not that I worry about it. I mean, I've been to the U.S. Supreme Court. I filed wrote and had a published writ of certiorari to the U.S. Supreme Court that was denied, and it's it's just more work, but I can't let it go just because I'm not going to let them win by default. If they told me, well, statute says this, or you're wrong because, they're just putting their fingers in their ears and not listening.
Yeah, this has been a fascinating. You just kind of illuminated how one little system can mushroom into all this other work that they generate for themselves. And I'm sure, let me get this straight, to get that transcript from the grand jury, I'm sure that wasn't free. And I'm sure that the analysis from this court-appointed psychoanalyst, or whatever you want to call them, that probably wasn't free either. You know, and about them, I mean, basically, they doctored the court record. Let's be frank. I mean, they wanted to doctor the court record to only let the information out to you that they want to withhold what they didn't want to withhold when you requested that transcript, right? I mean, there's no getting around that.
And see, what I did was I went to the opinion of the Indiana Supreme Court, and they said that I made threatening statements or veiled threats and, you know, all this stuff. Well, if I made veiled threats of violence, they would have obviously taken my computer. Probably federal law enforcement had been involved because I was living in a different state at the time. Nobody did any of those things. But what I did was when Chief Justice Loretta Rush said, "Oh, I made threats of violence," I went to the records of the transcript, and there's no instruction for that. So if you want to play that game and say that I made hidden threats, fine, we'll assume that. But that has to be in the grand jury record because you can't change it at trial while you're prosecuting somebody. And so then I went in and did that. And so every time, like, I say, stop, let's look at this isn't right, then that's how they build this element of craziness that I allegedly suffer from. And it's numbing to some extent, but it's just intellectually, it's so difficult for me to comprehend how these people go to law school, how they can hold positions and do all this stuff, and just do it from an intellectual standpoint. Why you would go so far. But the thing is, they found somebody who was willing to go as far, but somebody also who wasn't going to go off the deep end. I wouldn't do anything violent because I would never want to give them the ability to say we were right about him. And that's what they would want more than anything, because that's not me. And then like what you two do, you give me the opportunity to come on this program and speak. I have a responsibility to you and everybody else who's come to me, because the moment I do something bad, then that discredits you, and everybody else's cause and everybody else's actions, because then they say, well, he's just crazy, and write your show off. And that's the kind of thing that I hold, where the Supreme Court specifically mentioned that I try to something about a disclaimer that I put in that I would never cause harm to anybody, and they call it like a shameless disclaimer to try to throw the scent off, essentially. No, it really was a disclaimer. I, just like my history shows, I'm not dangerous. And their argument is I haven't done anything yet, so it's going to be bad when I do.
It's unbelievable. I mean, it's just surprising, but not shocking to hear this. But I mean, to think that you lost 2.5 years of your life for what? And you can't even put your finger on it. And that's the most disappointing, absurd part of this whole story.
And the thing that makes them the most furious is that I do it with a smile, but that's just who I am. I got, when they sent me to, it's a place called RDC, where they distribute the inmates throughout the Indiana prison system from the counties. I show up and they're saying, don't uncuff him, don't uncuff him. He's, we got something that he was potentially dangerous. And there's people looking around like the inmates working in the area are just shocked because they just never do that. somebody called from Dearborn County and wanted me to, whatever, be roughed up. I couldn't go to a level 1 security prison because they said my crime was more serious than what it appeared. And they put me in a position to, because they wanted to see me hurt. Well, I'm Facebook friends with people. I chat on an everyday basis with people I've met in prison. I mean, because of who I am. I never felt I was better than anybody. I just become friends with these people. I helped people when I was there, family situations, just perspective of, because you have a middle class white guy who's never been any kind of, problems. And I'm in there with, inner city African Americans, in there with, Mexicans who have been arrested, who weren't legal and things like that. So I got the opportunity to experience everybody. And everybody respected me because I'm not racist. I'm not and I would stand up for anybody. But so I come out smiling, and that infuriates them because they're not going to keep me down. No matter what happens. For one, I stood up for what I believe, and I tried my hardest.
That attitude is incredible, and I can say that most people would not have that attitude. So I mean, thank you for coming on and sharing the story. I mean, it's just very unfortunate, but I can't say that I haven't heard, horrible stories like this.
And thanks for having. But the thing is that as a person, I've grown a lot and I've learned a lot. Even prison, if it was squeezed into maybe 3 weeks, it would have been a much better. It was a learning experience. But I mean, just as I'm working on a rehab project right now, changing back a three unit house in the city of Norwood. It's in Cincinnati, where I grew up, and it's near my mother's house, so I spend time there because I'm 2 hours from home, and I need a sweatshirt, and I grab an old sweatshirt out of the closet, and it has my Indiana DOC number, Department of Corrections, and the first thing I do, I kind of laugh, take a picture of it, and send it to my buddy. They called him Black. My buddy Black, who I'm Facebook friends with and keep in contact with, and he's laughing about it because who does that? But I'm like, I had to keep some kind of souvenir from the trip. But that's what I want them to see. If somebody sees from Indiana sees this, is that I'm coming out smiling, and I'm not done. So hopefully I come back on the show and tell you that everything worked out and we've held some people accountable.
That would be great. I hope that we can showcase that.
Yeah, sure. Thank you.
Yeah, I'll say one thing too, Dan. You said several times through the show that you're not dangerous. People like you are extremely dangerous, just like myself. I'm extremely dangerous to the legal system. Just like, Christ is not very dangerous, but is very dangerous to Satan, of course. You know what I mean? So a lot to do with perspective. But what you said about keeping your cool, and as Sarah alluded to earlier, I'm furious at the legal system, and it did, 1/10 as much damage to me as it did to you. That's why we do what we do. We're trying to prevent people like you and me and other victims, and you're one of 50,000, if not more like 200,000 or 300,000 innocent people in prison today that don't belong there. You're one of several. So all good comes out of evil, and that's what we're trying to do with our project here, is just to inform, just basically what you've done. And we've gone an hour here, so I'd like to conclude our special 1 hour episode of our 30-minute show, the Legal Power Hour. Thank you once again, Dan, for being on our show. We'd like to tell everyone that they can catch our show fresh every first Monday of the month at 7 p.m. Eastern Time, or view it right here afterward on our YouTube channel.
Oh, can I put in one thing real quick?
Yeah, you can. You sure can.
I do have a blog that people, if they want more information, they can go to danbrewington.blogspot.com. And everything I've talked to, all the documentation is up there, and everything that they said was threatening through my divorce or harassing or anything like that, that's still up there because they didn't ever force me to take it down or even attempted, force me. So danbrewington.blogspot.com for more information.
People can verify everything and look for themselves, is what you're saying, right?
Yeah, yeah.
And in fact, we have a blog too. Be sure to subscribe to our blog. You can get monthly informative posts, just like you can with his blog as well. And our address is www.stl.com/blog. And of course, if you want to protect yourself to the fullest extent possible against our wildly corrupt legal system, copy of our book, Stack the Legal Odds in Your Favor. So once again, Dan, it's been a fascinating discussion. Thanks again for being on our show. Again, like Sarah says, we'll have to have you back, and much better news.
Thank you.
Thank you, Dan.
Take care.
You too.
Yep. Bye.